specific beneficiaries, the specific property, and there must be a transfer of property to the trustee. Who is eligible to create the trust? The one who can make a contract, who is eligible to uh, make a contract. And there is one difference, that the trust can also be created by a minor, but with the permission of competent civil court. If the court permits, even a minor can create a trust. And trust is created in the like manner as you know about the cell deed, the manner in which the cell deed is prepared, the like manner the trust deed is prepared. A deed is prepared, which is, you must have heard about the sale deed, etc. In the like manner, the trust deed is prepared, and this deed must have all these essentials with regard to the formation of the trust. Now, the extinction of trust. How a trust which has already been created, how it is extinguished, how it is comes to an end. This thing is given from section 77 to 79, 77, 78, and 79. Three sections are devoted for this. Trust is extinguished. There are four reasons when the trust is extinguished. Yes, please comment. Yes, section 77 says that the first thing which is given in section 77, which is when the purpose of the trust is completed. When the purpose is completely fulfilled, the trust is extinguished, comes to an end. There, as we know that in the trust, the purpose, there must be specified and clear purpose mentioned in the trust. It is one of the essentials. If that purpose is fulfilled, is completely fulfilled, the trust is extinguished, will come to an end. And it depends on the situation, which type of trust is created. For example, if a trust is created for by A, B is the trustee for the benefit of C's children, and trust is up to the youngest son of C. There is the limit. Now what happens after the youngest son? After that, the trust says that the remaining amount will equally be distributed among all the beneficiaries. That's all. What does it mean? It means that the purpose of the trust is fully, completely completed, fulfilled. When the purpose is fulfilled, the trust comes to an end. The second thing in section 77, that as we know, section 4 provides about the lawful purposes. What are the lawful purposes? It must be according to by law. According to law, it must not be forbidden by law. It must not defeat the purpose of the law. It must not be immoral or opposite to public policy, etc., etc. If after the creation of the trust, if the purpose becomes unlawful, in that case the trust is bound to extinguish, to be extinguished. It is the extinction of trust takes place, or the trust is extinguished. But sometime it happens, you must have must have read in the Indian Contract Act, that there are certain contract and the certain part of the agreement is legal and other part of the agreement is illegal. You must have gone through section 57 of Indian Contract Act. The same section is applicable here. What is section 57 talks about? If the both the part are separable, they can be separated. In that case, the legal part, the lawful purpose, lawful agreement will remain as an agreement, as in contract, but unlawful part will become void. The same thing is applicable in the trust laws. And the second situation, now we are creating the unlawful purposes. Okay. But there may be a situation, a trust may be created for a particular purpose, and for any reason whatsoever in future that purpose is dissolved. In that case also the trust is extinguished. For example, for NLU Assam has been created by a trust for LLB education. It is created for the students to have the LLB or law education. Supposing for a while it was created by a trust. But for any reason whatsoever, somehow after some time, this campus of this university was turned into, or is going to be turned in some other government office, and the government took the decision that instead of the university, now this campus will have a certain office, certain department, and it is no more university. It is no longer university. But here the thing is, it is just for the sake of example. Okay, what is there? That it was created by a trust, and there was a specific purpose in that trust. Now that purpose is changed. That means the actual trust or the trust is extinguished, finished. Next point in section 77, and it happens so many times, when the trust is created, After the creation of the trust, the subject matter itself is destructed. Destruction of property. If the subject matter of the trust is destructed completely, what happens? That means the trust comes to an end. For example, a trust was created in your campus. Somebody created a trust that there should be an overbridge from airport to the campus. Somebody created a trust when you become the senior advocate, senior leading advocate in the Supreme Court, so obviously you will do something like that for the campus, for the university. Hmm? When you will not be knowing about your income, how much you are earning. Hmm? So as you know, the sky is the limit in this profession. Anyway, a trust is created, certain money is given in that trust for a purpose, and what is the purpose? That an overbridge from airport to university will be constructed. But after some time, for any reason, this university, this campus was shifted to somewhere else. Just for the sake of example, suppose it was shifted to Dibrugarh. As the purpose is entirely changed for the purpose for which the trust was created. Now, you see, it is not possible. The implementation of the trust is now not possible. If such a situation arises, that means the trust is extinguished. The last point in section 77 is the revocation of trust. It is extinguished by the revocation of trust. We discussed when we were talking about the kinds of trust. The trust may be revocable and irrevocable. If it is a revocable trust, and the author of the trust revokes that trust, that means the trust is extinguished, comes to an end. If the power of revocation is specified or is specifically kept by the author of the trust, he may revoke that trust at any time. As it happens in the case of will, when somebody makes a will, can he change the will? Yes,
Yes, sir.
he can change a will. He can change as many times as he wishes. And the last will shall prevail. Right? So suppose if a trust is created by a will, and in that will, the power of revocation is kept with the author of the trust. In that case, he can revoke that trust at any time. It can also be revoked otherwise. Otherwise means which is not in the hands of author of the trust and which is provided under section 78. What is the meaning of otherwise? So for that, when all the beneficiaries, if they are eligible to make a contract, competent to make a contract, so by the wish of all the beneficiaries, and you may be noting that till now you have not seen any role of beneficiaries. But if there is a trust and there is a beneficiary or number of beneficiaries and they are major and qualify other essentials for making a contract, in that case, with the consent of, if all consent, all the beneficiary consent, a trust is can be revoked. Right? Revocation of the trust is given in section 78. How a trust can be revoked. One is by the consent of all the beneficiaries. Second is if the author of the trust, if it is an express trust, keeps the power of revocation with him, he can revoke that trust at any time. And the third is the case of payment of date. If the author creates a trust for the payment of date, and if this knowledge of this trust or about this trust, if it has been communicated to the creditors, in that case that trust cannot be revoked. But if it is not communicated, though the author of the trust has created the trust, he has created the trust for the payment of debts. Suppose A creates a trust, B is the trustee, and C, D, E are creditors. A creates a trust, makes the B trustee, and asks B pay off these debts to C, D, and E. Trust is created, but it was not communicated to C, D, and E. If it has not been communicated, in that case, the trust may be revoked. And if it is communicated to the creditors, C, D, and E, or they are the part of that settlement, that deed, trust deed, in that case, it cannot be revoked. And it is the same case with the communication of revocation and under Contract Act. You may recall section 4. Very interesting topics with regard to the communication of revocation. When it is revocable and when it is not revocable. It was section 78. Okay, there are small sections, no issue. The last section is section 79. Section 79, there may be a situation where the trust is created, and on the basis of that trust, trustees may have performed certain acts. In that case, if the trustees have performed certain acts in the execution of that trust, in that case, the trust cannot be revoked. The trust is always prospective, not retrospective. Revocation not to defeat what trustee have duly done. Section 79. No trust can be revoked by the author of the trust so as to defeat or prejudice what the trustees may have duly done in execution of the trust. There is the power of revocation in the hands of author of the trust, but there is one restriction. What is that restriction? After the creation of the trust, trustee may have taken some steps, may have performed certain duty provided in that trust deed. It is not in the hands of the author of the trust to cancel those uh, acts, those performance of the trustee. The power is with him to revoke the trust, but it is prospective. And whatever was done by the trustee, that is done. It cannot be changed. There are very small section uh, 77.